this video I want to take a look at reasonable accommodation for a person with a disability in the workplace. There is an interesting recent case that I've written about there on my website employmentrightsireland.com, and it's to do with the prison officer who had back problems. The back problems arose from injuries in the workplace, but that's immaterial and irrelevant to the point of this case. The background is it's a High Court case. In the first instance, the prison officer, Robert Cunningham, brought a claim under the Employment Equality Act 1998 against the Irish Prison Service. He claimed that the prison service had failed to make reasonable accommodation for him to continue in his employment, and he was a young man. He was only 40 years of age, and he had an exemplary record in the prison service. He was offered a lower ranked job with a significant drop in wages or a retirement on health grounds, and this didn't suit him, and who could blame him, I suppose, because he was going to be looking at a significant drop in salary. The Irish Prison Service relied on Section 37.3 of the Employment Equality Act 1998, and it basically says that it is an occupational requirement for employment in the Garda Síochána, prison service or any emergency service that persons employed therein are fully competent and available to undertake and fully capable of undertaking the range of functions that they may be called upon to perform, so that the operational capacity of the Garda Síochána or the service concerned may be preserved. So the prison service basically said that this gave them an exemption from the obligation imposed by the Act to make reasonable accommodation for somebody with a disability. They were saying quite clearly that this was, from their perspective, a get out of jail card. This man was unable to do the full range of duties, was unable to do, by reason of his back problems, restraint and physical stuff like that. Mr. Cunningham brought a claim to the Workplace Relations Commission and he won. The employer appealed the decision to the Labour Court, and the Labour Court decided, interestingly, without hearing evidence, that the prison service had an exemption pursuant to Section 37.3 of the Act, and it allowed the prison service to be exempted from the obligation to provide reasonable accommodation for a person with a disability. Mr. Cunningham, however, appealed this decision to the High Court on a point of law. In the High Court, his senior counsel, Cleena Kimber, senior counsel, argued that he was entitled to have reasonable accommodation under the provisions of the Employment Equality Act 1998, and that Section 37.3 did not give the prison service an exemption. On the other hand, Mr. Ward, senior counsel for the prison service, said that the prison service was indeed exempt from the obligation to provide reasonable accommodation. Now, the Labour Court had not heard any evidence from workers who were accommodated with restricted duties on a long-term basis, and held that Section 37.3 provided a complete exemption to the prison service due to Mr. Cunningham not being able to perform the full range of control and restraint duties. The Labour Court did not hear any evidence, though, from workers who were accommodated, and in the prison service, as you can imagine, it's a big service with a lot of employees. There is a lot of different roles, different tasks to be carried out. Mr. Ward, however, for the prison service senior counsel, contended that the Act should be interpreted by giving words their ordinary and natural meaning, so as to give effect to the Oireachtas, and the wording of 37.3 was clear and unambiguous. It came on to the High Court then, and the High Court referred to the Supreme Court decision in the Nano-Nagel case. It basically dealt very significantly with the whole question of reasonable accommodation and what is the employer's obligation in terms of making reasonable accommodation. And basically the Supreme Court held that the employer was not obliged to create a new job, and was obliged to make reasonable accommodation only insofar as it would not be as long as it was practicable and wasn't excessively expensive or costly. However, the High Court basically said that the circumstances of the case will dictate any particular argument or any particular claim such as this one, and that in larger organisations there may not be a single characteristic function which is essential to be performed by all employees. The High Court referred to a Garda Síochána who, for example, may be confined to a wheelchair but would be able to carry out desk-based duties and perhaps IT duties and forensic science duties and so on. In other words, he wouldn't be able to do, or she wouldn't be able to do, the normal restraint and physical work that might be required on the ordinary course of duties, but would be able to do other work. The High Court held basically that the Labour Court was in error in failing to hear evidence and make findings of fact in the case, and made a point of law that the interpretation of a particular section in the statute does not exist on its own or in a vacuum. It must be applied to the facts in order to reach a determination in a particular case. Clearly, the Labour Court, who did not hear evidence in this case from other employees who were accommodated, did not do that. So no evidence was heard by the Labour Court, and the High Court held that all factors should have been considered in the particular case before it. The High Court held that the exemption contended for by the Prison Service did not go as far as claimed, and the requirements of the directive dealing with disability and equal access to work and so forth, that the employee be given reasonable accommodation to be permitted to continue in the employment. The High Court held that the correct interpretation of section 37.3 was not that the employer was exempt from the obligation to make reasonable accommodation for the person if it was not unduly burdensome for them to do so. The High Court sent the case back to the Labour Court for consideration of all the factual evidence in the case, and held that everything will turn on the facts of a particular case and the size and nature of the emergency service concerned. Justice requires that the person suffering from the disability be given the chance to make his or her case, that they could perform the functions required of them if reasonable accommodation were made for them. It's an interesting case. It's a High Court decision. It's to do with the Employment Equality Act 1998. It's to do with the obligation on the employer pursuant to that act to make reasonable accommodation, and it's to do with the particular section of the Act 37.3 which appears to give an exemption to the likes of the prison service and the emergency services and the Garda Síochána, but in fact the High Court held in this case that every case must be judged on its own particular circumstances, and if the organisation is of such a size that an individual can indeed be accommodated by being given reasonable accommodation, well then he or she is certainly entitled to that. The case was sent back to the Labour Court. Useful case, interesting case. If you find this video useful, I would appreciate if you gave it the thumbs up down below. Thank you.